Hi, I'm Wani, and today we'll be talking about public interest and private interest. And we'll look at how intellectual property law would balance these two very distinct interests.
Now, before any discussion may proceed on the balancing of public and private interests, the definition must be first established. Public interest for purposes of this discussion would be the interest and welfare of the public at large when potentially benefiting from a certain innovation or invention. This interest might be supported and might be also driven by factors of public policy given by the government, such as national security, public morals, public order, or other factors when it comes to innovations that might potentially harm the public at large. Now, the ongoing COVID-19 pandemic is one large factor that might potentially tip the scale favoring public interest over private interests. Moving on to the definition of private interests would be that private interests are, for purposes of this topic, simply the interest of the owner or creator of the intellectual property in question. The distinction lies within the fact that the owner of the intellectual property need not be the creator of the intellectual property but have acquired such interest through the proper avenue available. The private interest of such individual lies in the fact that the law allows them to exploit and monopolize their intellectual property for a certain duration of time. Now, the balancing of interest is a constant endeavor of the law, and the law is constantly balancing rights, and the protection of interests afforded to private individuals cannot be left unrestrained on grounds of public interest. So a flexible approach is usually taken to adapt to a rapidly changing context that is seen usually in intellectual property law. Now, moving on to the topic of copyrights, which is governed under the Copyright Act 1987. Copyright seeks to protect artistic expressions and literary works. The significance of balancing such rights will be to ensure that not everything can be copyrighted and that the rights of the individual being granted the copyright is not unfettered. Now, the challenges that we might face will be the rise of the use of electronic versions of copyrighted works and the ease of finding pirated works on the internet concerning these copyrighted works. Now, private interest is guaranteed by the courts if a work eligible for copyright is infringed upon, as seen in Section 36 of the Copyright Act, and the remedies for damages are available for the private individual, as seen in Section 37. The private individual's interest is eligible for copyright protection if the work is a literary work, a musical work, an artistic work, a film, a sound recording, or even a broadcast, as seen under Section 7. Copyright protections of private interest extend to that of a performer, as seen under Section 10A, and the rights of the performer is that of exclusive control over the performance that is being performed. Now, public interest is taken into consideration in a claim of copyright works and limits certain private interests under certain circumstances. Now, the first one being originality, and that's because the rationale behind the granting of copyright is that the copyrighted work must have been the result of effort, skill, and judgment, as seen in Lao Fusan, and the granting of exclusive rights would compensate for that effort. Ideas that are commonplace and unoriginal and general, such as a codified set of rules for a well-known activity or a title of a book or film that contains a very general phrases, cannot be subjected to copyrights on grounds of public policy. Now, the issue of fair dealings seen under Section 13, Subsection 2, Paragraph A for non-profit research, private study, criticism, review, or the reporting of current events by the public is also not an infringement as long as the authorship is acknowledged. This is also based on grounds of public interest. Now, the defense of fair dealing is also afforded to the government on grounds of public interest when it comes to published editions of works, as seen under Section 9, Subsection 4, and 5. Now, the backing out of computer programs under Section 40 are also not infringement based on grounds of public interest. Now, the duration of copyrights under Section 17 to Section 23B is usually for 50 years after the death of the owner. Is similar to the rationale behind the rules of perpetuity, where the owner is no longer able to practically benefit from such copyrights. Now, the license to produce and publish translation in national language under Section 31 presumably also has certain public interest consideration, as it allows the work to be more widely circulated, as people in Malaysia are presumably more literate in the national language than in any other languages. And the law seems to provide an adequate amount of consideration when it comes to balancing both private and public rights in copyright laws. And the court's approach to such application and enforcement of the law is in a flexible manner, and allowing discretion to the courts when dealing with challenges from the rapid rise of pirated publications on the internet, and also the tendency of infringement on software programs. Now, moving on to the topic of patents, which is being governed under the Patents Act 1983, patents differ from copyright, as copyright is usually a protection of artistic or literary works, whereas patents usually protect inventions or innovations. It requires more complex requirements in the procedures before a successful grant of patent is being obtained compared to copyrights. This is being governed under Part 6 of the Act. Now, the amount of effort, time, and capital expended to obtain a grant of patent justifies the monopoly that is being tipped in the favor of the protections of the individual's private interests. Therefore, the only significance of balancing both the public and private interest in the law of patent is when it concerns public interest in the face of a national crisis, or when an invention is contrary to our public morals. Patent protects the private individual under Section 18 in cases of infringement through infringement proceedings under Section 59. Where an infringement is being proven, the remedies available to the owner of the patents are also wider than that of copyrights, such as injunctions from imminent infringement and damages under Section 60. Legal actions can also be taken by a licensee and beneficiary of compulsory license. In balancing both public and private interests, the law of patents have provided for various mechanisms in which public interest can be taken into account. The provisions of inventions and innovations not eligible for patents under Section 13 would have seemed to have an underlying consideration of public interest, as it does not allow the grant of patent to innovations or inventions that are considered too potentially wide in its application and that would exclude the public at large from benefiting from it. Other considerations of public interest can be seen in the refusal for the grant of patents on grounds of public interest and morality, as seen under Section 31 sub 1, and the duration of patent is usually limited to 20 years. Provisions on Act deemed to be non-infringement also allows for the exploitation of an invention or innovation on obtaining through purchase, and allows for exploitation of a patent with the consent of the owners. Now, moving on to the issue of government's right in their discretion in light of a national security or health crisis, will allow the government to exploit a patent even without the owner's consent, as seen under Section 84 sub 1 paragraph A. Anti-competition law is when a judicial or relevant authority has determined that the manner of exploitation of the owner of the patents or his licensee is anti-competitive, and the government may exploit the patent even without the owner's consent, as set under Section 84 sub 1 sub B. In the situation above, the government needs to notify the owner as soon as it is reasonably practicable. Now, moving on to the issue of compulsory licensing as defined under Section 48, it might be also sought if the benefit of the public at large where there is arguably a violation of anti-competition laws. Now, the system of patents can also be seen to be in favor of the private individual's interest. But in fact, it could be also said that the integrity of the patent system and its efficiency in protecting private interests is also in the interest of the public, as seen in the case of Aventis. It allows and encourages innovations in the country that would boost the nation's economy, ultimately benefiting the public at large. As aforementioned, there are not much challenges being posed to the balancing of interest in the law of patents, except perhaps in a national emergency like COVID-19, where the exploitation of patents can be done without the owner's consent. The only real challenge then would be to determine what amount would amount to adequate compensation under Section 84 sub 1 sub B paragraph 3. Now, moving on to the issue of trade secrets. Trade secrets might be distinguished from patents in the sense that trade secrets benefit from the fact that they are veiled in secrecy, whereas patents benefit from the fact that it is disclosed to the public and can be available from purchase in an open market. Trade secrets, unlike other kinds of intellectual property, usually arises through the owner's own initiative through a non-disclosure agreement or through a confidentiality clause. That is to say that unlike other kinds of intellectual property, the owner does not seek to exclude the world at large from exploiting such secrets per se, but rather seek to oblige an individual from disclosing such secrets. Thus, it is usually dealt with under the law of obligations or contract, and is governed mainly by principles from case law instead of a codified statute. Any dispute arising from trade secrets under the breach of confidence would usually involve the balancing of the interests of two individuals instead of the balancing of private and public interests. Trade secrets arises from initiative of the individual which wishes to rely on the law concerning trade secrets to their benefit. Trade secrets can be argued to be very much in favor of private interests in pursuant to the doctrine of the freedom to contract. This is further aided by the fact that the owner is actually required to take active steps in ensuring secrecy, as trade secrets are only recognized if it is kept confidential and has value due to its secrecy, and also is the subject of reasonable efforts by the rightful holder of the information to maintain its secrecy. The rights of the owner of a trade secret can only seek remedy if they can prove that there was a breach of confidentiality. And a prerequisite for that is that the secrecy of the subject matter must be clear and specific, and that the individual accused of breaching the confidence must have access to the confidential information, as in the case of Dynacast. The only two issues in which public interest might be relevant in terms of trade secret would be the issue of restraint of trade, illegal under Section 28 of the Contracts Act 1950, and the issue of anti-competition laws governed under the Competition Act 2010. On the issue of restraint of trade, which is clearly contrary to Malaysian law, the courts will not give effect to the confidentiality clauses which ultimately carry such effect. And the restraint of trade clauses are against public interest, as that the restriction of labour market's flow of labour would tend to lead to an inefficient labour market, jeopardizing the economy. The courts, however, might give effect to a clause of perpetual confidentiality so long as it does not in effect restrain the trade of the employee and does not violate competition laws. It might be important to note that it is in theory difficult to find violations on competition laws in regards to trade secrets, because trade secrets are not protected by law from reverse engineering and independent development from individuals not bound by the confidentiality clauses. In regards to trade secrets, there is much discretion being afforded to the courts due to the constant uncertainty and unforeseeability in its application. And public interest plays virtually no role in this kind of deliberation, as the law of trade secret does not practically affect public interest. However, if in the unlikely event that it happens, flexibility is being accorded to the Malaysian courts due to the fact that most of the laws on trade secrets are found in case law, and one is confident that the courts with its experience would successfully balance both kinds of interests. Now, moving on to trademarks before concluding. Trademarks originated as a means of communications and identification under Section 3, Sub 1 of the Trademarks Act 2019. In fact, trademarks originally serve public interest more than it serves private interest, as it concerns consumers' protection. However, the shift in recognizing trademarks as a form of intellectual property does in fact tip the scale in favor of protection of private interest, as seen under Section 16. The challenges in such would be whether there is sufficient justification for such shift in balance, and also how these interests are affected by the use of trademarks in cyberspace. The significance of being able to balance these rights would be to allow a better distinction between the overlapping functions of both copyrights and trademarks, and prevent unfair exploitation when it comes to companies trying to protect their trademarks or logos under both kinds of intellectual property. The Trademarks Act 2019 confers private interest to the owners of registered trademarks under Section 48, and any infringement might be a cause for action for remedies such as injunctions, damages, or accounts of profits seen under Section 56. Rights are also accorded to the licensee under Section 70 and exclusive licensee when it comes to an infringement. The justification for treating trademarks as a property would be the fact that well-known trademarks are practically commodities in themselves, serving purposes for identification while holding certain properties of desirable aesthetics that might be merchandise, bringing profit for the business in question through collaborations and the likes of it. Like other forms of intellectual property, the law limits what might be registered as trademarks. The requirements of distinctiveness is a requirement that provides grounds of absolute refusal for registration, seen under Section 23, Sub 1, Sub B. Furthermore, it refuses the registration of marks that are customary in nature, lest it devoids the public the benefit of using those marks in good faith. Furthermore, grounds of public interest or morality for refusing registration can be seen under Section 23, Sub 5. The rationale behind public interest grounds, apart from morality and national security, are also to ensure that trademarks serve their intended purpose to communicate the origins and quality of the product instead of confusing the average consumer. The provisions on act not amounting to infringement under Section 55 can also be said to have an underpinning consideration for public interest, as it ensures that the public can use certain marks similar to that of a registered trademark in good faith. The law on trademark would seem to have a decent balance of both kinds of interests, both public and private. In fact, one might also argue that it is in public interest for trademarks to be considered private property, as it is closely associated to the proprietor, as this will ensure the proprietor of the trademarks to ensure the quality of their products or risk losing reputation associated with the individual's trademark. This is significant because it would then be able to provide a proper framework to assist the balancing of interest when it comes to new developments of new kinds of trademark, which might include scent or holograms, which are trademarks that are fairly novel. Now, the challenges of trademarks in cyberspace might not be a new one. However, it is a chaotic scene when it comes to the enforcement against phishing sites trying to pass off as reputable sites. Now, this issue has to be addressed immediately, ideally by legislation. However, in absence of legislation, the court seems to have a flexible approach to adapt to the changing developments. In conclusion, while there are many significance in balancing private and public interests, where an individual's rights should not be left unrestrained, however, it is impossible to precisely define what kind of rights, what kind of interest entails, as they usually change based on context and are easily affected by changing social developments, much less to balance them perfectly. In fact, one might argue that oftentimes these interests overlap, and therefore it is undesirable for the courts to formulate a rigid approach for balancing individual rights, but to adopt a flexible approach. One would submit that Malaysian law manages to successfully balance both kinds of interest in this regard. For example, Malaysian law would allow the vaccine for COVID-19, if developed, to be exploited for the benefit of the public good, even without the consent of the patent's owner. It also attempts to balance the owner's private interest by paying adequate remuneration in looking for potential legal concepts to encourage the effort of balancing both public and private interests. One would suggest the introduction of the concept of adverse possession into intellectual property law to discourage owners of intellectual property to sleep on their private interests without actually using them. Thank you.